Okay, well, good morning and welcome everyone to Kennore's Business Growth webinar series. Today's topic is anatomy of an M&A deal. And we're joined this morning by Robert Dixon, who is our expert host. So, the topic today is whether you're considering buying or selling a business or just want to understand the process a bit better. This session will provide insights into deal structure, timelines, term sheets, due diligence, and the regulatory considerations. So, a little about Kennore. It's a firm of over 75 staff specializing in offering compliance and business support services. We provide outsourced bookkeeping, payroll, and management accounts, so an outsourced CFO service for SMEs across Ireland, as well as providing outsourced corporate governance and minute taking service for a number of large businesses. So we are a multi-award winning online accountancy and company secretarial firm supporting SMEs across Ireland, Northern Ireland, and the UK. My name is Christina McGreevy. I'm the head of sales and marketing here at Kennore. So I'm responsible for the teams that are engaging you from your initial inquiry stage and help you with a discovery call and bring you through a journey to take you on as a client of Kennore. This morning's expert guest is Robert Dixon, partner at Mason Hayes and Curran. Robert advises a broad range of Irish and international clients in many sectors. He advises on private mergers and acquisitions, corporate investments, private equity, joint ventures, and shareholder agreements. So, one thing to note is that this webinar is for general information purposes only. For specific advice, we always recommend reaching out directly to an expert, and we'll share our and Robert's contact details at the end if you have a need for more questions. So that being said, Robert and I are happy to take questions throughout the session and would like to see interaction from you throughout. So please use the chat or the Q&A feature and I'll pose your questions on your behalf. So I'll now hand over to Robert to begin. Good morning, Robert. Hopefully it's sunny with you.
Yeah, it is. It's lovely. Thanks very much, Christina, and thanks for the introduction. It's great to speak with Kennore again today and with some of your clients and talk a little bit about, mergers and acquisitions that might be relevant to some of the attendees in terms of the considerations and process around that. It's what I do for a living, and our big kind of corporate M&A team that we have here in Mason Hayes and Curran can guide, or we do all the time, guide clients through that process, which there's a fair bit, as we'll talk about in the next little while. There's a fair bit in it, particularly if it's not something that you've done before. So it's just worth trying to prepare and understand as best you can in advance, because once you get into it, it's there's 50 things being thrown at you every minute. Well, not every minute, but a lot of minutes.
Yeah.
That it's best if you just know what you're going into and you understand it in advance. So a session like this hopefully can help with that.
I've no doubt, Robert, with all the detail that you're going to go into, that it will really set people up for success. And the key is preparation, isn't it? So
yeah, no, I think that's absolutely it, and I'll talk about that in a few different ways, because there's different aspects to a deal, and I suppose that's the next point here. You can obviously it's a little bit artificial to break it, because a deal is kind of, it ebbs and it flows in different ways, but there's different parts to it really, and this isn't in terms of one after the other, but I think the key parts of a deal really are agreeing the terms. So you have no deal if the two parties aren't at one on what price is being paid, what's the kind of protection at a high level package being given, what's actually being sold, is it all of the business, is it a unit of the business, etc. Due diligence, hugely important. So if a buyer is going to come along and pay 10 million or 20 million or whatever it might be for a given business, they're going to, in this day and age, generally want to do an exercise on that, which is due diligence, which is looking at all of whatever aspects of the company they're interested in checking, I suppose, that legal due diligence, potentially financial due diligence, tax due diligence, and so forth. So, that's a process, and there's a few aspects to it we'll talk about. The document negotiation. So, and all of this, by the way, is private mergers and acquisitions we're talking about. So none of this is kind of legally required, if you like. All that's legally required, if you want to buy a company for 20 million euro, all you have to do is sign a stock transfer form. But the problem is, somebody isn't going to want to hand over 20 million euro generally without actually agreeing a deal, agreeing protections, agreeing the parameters, and carrying out a due diligence process and knowing what they're buying and what the risks are and what the gaps are. So that's important. And then the other thing, sorry to contradict myself, I say all you need to do is sign a stock transfer form. You may be in breach of some laws if you do that, actually, because with some depending on the type of acquisition, there may be regulatory hurdles you need to overcome before you can consummate the transaction. So, for example, if it hits the thresholds for an antitrust filing, if it hits, there's a new regime I'll talk about a bit more, but foreign direct investment screening, there is since January a new regime in Ireland, which is a much lower hurdle actually than the competition one. So a lot of transactions that are international are getting hit by that. And then there's, depending on the sector, there might be a central bank issue in terms of needing clearance. There might be a kind of HICWA, which is the health authority as such. So there's different things that can come into it depending on your sector, and it's important to know early on whether any of them apply, because it's a big part of the work streams to get the deal to the end. And then I think just signing and completion. So you have your deal, you have your deal, you have everything kind of agreed. The buyer's happy with their due diligence, but there's actually still quite a lot to pull together in terms of completion of the deal, and we'll talk a bit about that. So they're kind of the key things to be aware of.
And you're absolutely right, Robert. Just goes to show the importance of engaging with, someone like yourself that's an expert in this, that's able to prepare and has maybe dealt with cases before. Because as you say, very easily you could end up handing over your business, let's say, without having the right terms agreed. And you could think that everything was arranged and agreed and a handshake, but handshakes don't hold up in when there's a dispute. What's more important is having the paperwork and having everything prepared for, really, isn't it?
Yeah, I think that's right, Christina, and it's kind of a pity. I suppose there's different mindsets there.
Mm.
It's a pity when what you've just described doesn't happen. I think there's great advisors out there who maybe aren't as accustomed to mergers and acquisitions, for example, and you just have to pick the right person who's experienced, because this could be a key life event for you, and you need the
Mhm.
right people in your corner, frankly. But listen, I get the different things come into it, but
Mhm.
I obviously I'm biased, but I do think that that's important, and you could there's an execution risk issue with it too, Christina, because if you don't have the right people advising you, the deal might never get there. So that's really
That's
important
fair.
as well. I think to actually get to the finish line, you need people who are able to get you there properly and have the experience to overcome the many hurdles that come up in M&A deals.
You're right. And there's nothing worse than having maybe, potentially either a buyer or a seller at the table and then frustrating them by not being prepared or not having all of the professional documents to hand or ready when they need them. And that's ultimately either going to risk slowing down the process on you unnecessarily or risk you them walking away essentially as well.
Yeah, and
I'm sure you've
again,
seen that.
for sure, absolutely, and it's a pity. I
Of course.
think when you go into an M&A process, if you're a seller, for example, if you're
Mm.
selling your business and you talk to someone who does this for a living, they will be able to tell you fairly certainly that you're going to get a list of due diligence questions, and it's not. It can be tailored somewhat, but it's fairly standard, and it's
Mm.
coming. So it's a bit of
Yeah.
a pity when it then takes 2 months to answer all those questions, which I've seen happen. And sometimes the deal can be badly thrown off course by that sort of delay. So you're absolutely right, Christina. Yeah.
Yeah, that's it. Okay. Okay, great. Would you like me to move on through the
Yeah,
slide?
yeah, I think
Yep.
so. And actually,
Perfect.
the next slide is very, very similar in fairness. I suppose it's just thinking of the deal. I've kind of conceptually talked about the different things you have to go through in an M&A deal, whereas this is the different phases. So, for example, here, the term sheet phase, that would be definitely at the beginning before you do anything else, pretty much, because you want to make sure you have agreed terms. Now, the next one is an interesting one. You can say the due diligence phase and the document negotiation phase. That can depend. I think there are definitely clients on the buy side. If I'm acting for a client that's buying a business that would like to get their due diligence very much either progressed or more or less done before they get into the documents, because whatever they find in the due diligence might have to feed into the documents. In other instances, you might do those two in parallel, the due diligence phase and the document negotiation phase. So that's just a question for the client and the situation. And then once those are done, you get into completion phase, which is, as I said, the loads of bits of paper and pulling together the bits and pieces, which again, you don't want to leave that until the end in terms of thinking through everything that's needed. You do have to think about, there's loads of deliverables, for example, and if you don't think about those until you have your diligence completed, otherwise, and you have your documents your key documents in agreed form, you could come a bit, or again to the delay point, you could suddenly find some issue that nobody's thought about. So again, that's an experience point. And I think then just the last little corollary at the end there is, I talked about the consents, but what the consents can mean is that you have to do a simultaneous, or you have to do a split signing and closing as opposed to simultaneous. So that changes the structure of the deal considerably, and even your share purchase agreements. Suddenly a whole load of things come into it because you're going to have this period where everybody is legally agreed to go ahead with the deal, but it hasn't actually closed until that condition is fulfilled.
Okay. Yeah. So a lot to be considered, and timing is very important, right, Robert? And timeliness, I suppose, of everything, hugely important there.
Yeah, oh, totally. And I think timing. I'll
Mm.
mention timing again, but it's definitely something we see in the market. Things are just generally taking a little bit longer for different reasons. Due diligence processes are perhaps a little bit more detailed than they might have been in the past in some instances. And there's just, I think, sometimes a lack of preparedness or different things come into it, but it's just some transactions are taking longer for sure. It's something that is being noticed time and time again. Yeah.
Okay. Interesting.
Okay, so in terms of knowing then how an M&A deal works, I think there's just a few things to be aware of in
Mm.
advance. So first of all, I think being ready and the deal momentum piece, we've talked about that a little bit, but it's really important, in a transaction that the momentum keeps going, that there's not sort of delays where nobody really knows what's going on and it slows down. I think whichever side you're on, whether you're selling or buying, I think it's a really good idea to sit down with your advisors in advance and consider what's actually important in the deal to you, and what are the key deal points that you want to achieve. Because as you get into the white heat, if you like, of the transaction, you can lose perspective on that. So if you
Okay.
sit down and do a little list of what you really care about getting out of your deal terms, and it's
Mm.
not just on the sell side, for example, it mightn't just be the money. It might be, the level of protection that you're not walking away with with a very significant exposure, for an indemnity claim or this sort of thing. So it's just different things like that. I think who is driving the process. What I mean by that is you probably should have somebody, whichever side you're on, there needs to be somebody keeping everybody else in shape. And sometimes that can happen organically and someone takes it on. But the risk on any transaction is just that nobody steps up and does that. And what that means is if somebody sends an email to somebody else, because there might be 20 actors, 25 actors involved in a deal, and it just takes one weak link in terms of responsiveness to really slow things down for everybody. So if somebody's sending an email and somebody else hasn't responded 3 days later, who is, obviously the sender should chase, but who is the person that's going to keep everybody else honest? I think responding to due diligence questions promptly is a point I've talked about. So it's a momentum killer if you leave things for weeks as a seller and just can't come back. Unlocking negotiation points. I think there's a famous book called How to Get Past No. So it's
Oh.
that idea of, sometimes people can become entrenched in a point and a counterpoint. We need this. We're not giving that. It's finding solutions. It's finding ways around where people feel that they can get comfortable with what you agree. And then I think the perspective point comes back to having sat down at the beginning and decide what's important. So what should you really care about? Because it's amazing that as you get to the final stages of negotiating a deal, the points that are left on the table can sometimes be things that really shouldn't be taking up everybody's attention, to be perfectly honest. And sometimes it requires a bit of perspective on, just does this, is this really important? Can we just drop it and move on? That sort of thing. But understanding the risks at the same time of not keeping with the point. And resilience and patience is just to understand that A, yes, it can take time to get a deal done, and B, it can be a bit painful sometimes. Stuff just when you solve one thing, another thing jumps up, and it's just being resilient and being ready for that journey and not getting upset or impatient when things go wrong, or because they do. It's a natural part of doing a transaction.
And I suppose, Robert, it's probably really important to plan time into your like into your week, to be sort of checking in on items and depending on how quickly you want to move along, but it's obviously going to take a huge amount of time for the business owner to handle this. So if they don't have a dedicated team or a dedicated person that's working on it for them, making sure that they have the plans in place that they are able to step out of the operations in order to handle this so that it does go through as quickly as possible.
Yeah, I totally agree, Christina. It's a really tricky question.
Mm,
I think, if it's a kind of a business owner who has to get into the weeds of this process and they don't have kind of a number two CFO that
yeah.
they can just, because sometimes you see, depending on the scale of the bit, sometimes the CEO or the number one, the
Hmm.
founder doesn't have to do that. So it just depends. But then
Yeah.
equally, certainly if it was me and I was the 70% or 80% owner of a business that was being sold, I wouldn't want to just pass off responsibility for the whole thing. Maybe that's just me, but
I
you
don't think
do
that's
have.
just you. I would say I
No,
would say that's most of us.
if it's your baby, you're going to care. But
That's it.
I think it's a good point. You do have to. I think the weekly that there's no substitute for the weekly call. Obviously, you don't want to do it too early because there'll be nothing to talk about. But
Yeah.
it's amazing how much gets done in the 6 hours before the 30-minute weekly call.
Right.
It just keeps everyone honest. If you said you're going to do
That's it.
something, then you have to have done it by the next.
Indeed.
And yeah, you do have to set a time aside. There's no substitute for it. It will take your time, some
Hmm.
of your time. I think it's always worth remembering, and I'm conscious of this always, that I'll make the point later on. There's no deal until it closes, or until there's binding document signed. The letter of intent is non-binding, so either party can walk away until it's binding. And therefore, the danger is you've totally focused on the deal, you've dropped the ball on the actual running of the business, and then your deal, your buyer walks away. So it's really important to somehow juggle the two, in terms of keeping your normal job up while spending whatever time is needed to achieve what you want here in terms of a transaction closing.
Yeah. Yeah,
So,
hopefully that's really helpful advice for everyone, I would imagine so. And I don't know if I mentioned it at the start of the webinar, just any questions that anyone has, they can pose in the chat or in the Q&A. We do have one question that's come through there, but it may be more tax question there, Robert. So I know that your specialism is in advising. So what are the tax implications of acquiring one of your own companies that you had a minority stake in? So that's probably something that requires some more specialist advice.
yeah, no, and obviously we have a specialist tax department here in Mason Hayes and Curran. I think,
Right.
to be honest with you, I think it's too broad a question. Like, you'd need the
Mm,
specific
definitely.
facts to actually advise on that. But certainly, if the person who asked the question wanted to get in touch, and
Hmm.
and possibly we might want to tease out a bit more detail on the ins and outs of that, because it probably depends on jurisdictions and different things. Obviously, we're Irish lawyers, and but if that question came through, we can certainly deal with it, and I'd bring one of my tax partners in to look at that, and it's
Great.
something we can advise on for sure.
Sure. So what we can do is Javid will be sharing Robert's contact details at the end of the session, so you'll be able to reach out to him directly then. So yes,
Okay.
thank you. Sorry for that, Robert.
Great. No, that's great. And please do, any questions anyone has. The six. The red circle says there's six things, but perhaps they weren't specific questions, Christina. That might have been you prompting people to
Oh,
ask questions.
yeah, it's probably the chats back and forth. Yeah, don't
Yeah.
worry, I'm in there.
Okay.
I'll keep you honest.
Yeah, that's fine. That's fine. Okay, so timelines. I don't want to be unhelpful with this, but it is, how long is a piece of string on an M&A deal? They really do vary. As I said, they have got longer. I mean, the
Right.
point from us as lawyers being instructed on a deal to when the point it closes if I was to sit down and plot that over a 5 to 10 year period, there's no way it's definitely got much longer. And you're talking often a deal is being talked about and it could be 12 to 18 months before it closes. That's what we're sometimes talking about. Now, in other instances, it can be really quick. There's no reason why it wouldn't be very quick. It's just that that's what realistically often happens. So you just have to be ready for that and try and avoid anything that's within your own control and delaying it if that's what you want. Try to avoid that. But it really could be anything from a few weeks, quite honestly, up until 18 months or 2 years.
Yeah.
So it's a real variety, a real mixed bag. And as I say there, we keep harping on, but preparation will accelerate deal timelines.
Mhm.
Then I suppose another thing on timing, again, I'm probably repeating myself, answering the due diligence questions quickly and populating the data room. And we'll talk about the data room a bit more, but those processes can lead to significant delays in the transaction. And then momentum, keep following up, have your key advisors engaged early, no delays there. I think how you deal with open negotiation points and don't let them stall things either. There could be issues lists, negotiation meetings, markups of documents, all of the above, the right thing at the right time, and just trying to move it quickly is the point. And setting clear deal deadlines, I think that's important. But I do think there's sometimes an issue with some very focused corporate finance advisor, and corporate finance advisors, when they do it right, are crucial and very, very useful on a deal. But if you set very aggressive timelines that no one's ever going to hit, you very quickly lose any credibility, and the whole deal, suddenly you've missed a deadline. Everyone's like, well, there's nothing now to work, So you have to set realistic deadlines that are within, that everyone really agrees to and signs up to and has thought through the detail on, because sometimes deadlines get put in place that are just impossible. So I think having those parameters to work to are crucial, but they have to be realistic.
Yeah.
Okay. I think did another question pop up, Christina, or we can move on?
Oh, one did actually, yes. From Cressida. In your experience, do business owners typically hold their shares personally or through a holding company? And
Yeah.
a follow-on question, she said, and are there any advantages to one structure over the other when it comes to selling?
Yeah, okay. So I would say in my experience, probably more often it's through a holding company, but
Mhm.
there's no, I suppose it depends for a start if I was to think in terms of advantages. So
Mhm.
if let's say, for example, I have a company here that's being sold, and then there's two or three shareholders up here. If the shareholders are giving, for example, warranties, they're giving protections on the deal documents, it would, of course, be better for a holding company to be potentially liable for a claim than for the individual to be liable for a claim. So, in that sense, on the corporate side, I would like, if I was acting for a seller, I'd prefer to see holding companies there. I
Mhm.
think, there are tax reasons, there are tax advantages and disadvantages, which I won't go into because it can be, there can be exemptions from capital gains tax
Yeah.
and that sort of thing. And then you also have to think of, is there a double hit on tax if you're recovering, basically
Yeah.
if a holding company is receiving the consideration as opposed to the seller, is there any issue there? So honestly, I think the biggest question is a tax question. And then
Uh-huh.
the other question is there any difference in exposure? Because if you have a company has limited liability, it can't pass up to the individual unless there's exceptions to that, but very limited exceptions and very
That's
unusual
it.
exceptions. So those are probably the two things to think about. You'd want, again, sorry to keep going back to tax, but it's really a question of tax, which is the more advantageous holding structure.
Yeah, that's it. It's about weighing it all up, isn't it, Robert? Whether it's from the tax point of view and from the risk point of view, you have to weigh up both, right? And that's where working with a specialist like yourselves can really help direct, because you can set them up initially, even before they go into the sales engagement, in having the best structure there for them that minimizes that risk and minimizes taxes, or where appropriate.
Yeah,
So hopefully that's helpful,
absolutely.
Cressida.
Yeah, and then also you just need to think about if you have an existing structure and you're
Mm,
changing it, just watching a transfer of, that doesn't create a tax event. If you're
right.
if you're if you're putting a holding company into the structure, I imagine you
Mhm.
could do it without creating a tax bill, but you just need to be
Yeah.
careful and get advice before doing it.
Before doing any of
On,
those.
on
Yeah,
the tax
absolutely.
side, yeah,
Yeah,
yeah, for
that's it.
sure.
Okay,
Okay.
great. Thank you.
Great. And then term sheet. So I
Term sheet.
mentioned these are the
Mm,
things you want, I would say, on every deal really to have
yeah,
signed before. Because if you start getting in and you think you've shaken hands per the little diagram there
yeah.
on a transaction and you're going to pay 10 million or 20 million for a particular business,
Hmm.
that's all very good, but there's a lot of detail in behind that you might be on different pages about. So what a
Yeah,
term sheet does in ideally several pages only, it kind of documents what you're expecting, what the two parties are signing up to. It's not binding, but it does have moral authority. So if you've signed up to a particular term in a term sheet, it's usually very difficult to renegotiate that later in the
right.
deal. Um, and you don't want a kind of pitfall with term sheets sometimes is people get a bit overexcited and create these really long documents, which are just a load of time is spent on them then. And it's I think you want to get the core points down there and then leave the greater detail for the longer form
Of
binding
course.
documents. And one thing I would say, if ever you're in a situation where a term sheet is put in front of you, don't sign something if there's anything in it you don't understand. It might be a problem, even if it's non-binding. It's hard to then it's very easy to say, well, will you sign? You signed the term sheet. You agreed that in the term sheet, so you can't change it now. So I would say make sure you get if somebody puts term sheet in front of you, make sure you get the relevant advice, particularly if there's something in it that isn't crystal clear to you. Um, I think it is crucial to flesh out the deal breakers at this stage. As much as I've said, don't put in reams and reams of detail. I think putting in something that's so vague. I saw a term sheet, for example, very recently that said, "Oh, we'll agree an earnout," and it really didn't have any. It might have said kind of the maximum earnout, but it didn't that could mean a world of different things in terms of how many years does the earnout go on? What do you have to do to achieve the earnout as seller? So it's important that really crucial core commercial things like that are in the term sheet because you want to get rid of any deal breakers before you all spend loads of time and money on a transaction. You know,
Right.
you don't want to find out late in the day that you can't reach agreement on the earnout, for example, or on the
Yeah.
price, these sorts of key things. And then just two more legal points are exclusivity and confidentiality. If you're selling a business, or indeed if you're buying, you want to make sure that all your discussions are subject to confidentiality. So make sure you have an NDA signed before you start handing away your hard fought and hard grafted sensitive details to somebody else because they're not under any obligation to keep it confidential unless you make them sign something. And then there's exclusivity. So again, this is more maybe a point if you end up on the buy side. I think I did see on the registration list somebody inferred that their business might be looking at buying as opposed to selling. And on the exclusivity side, it's just if you are spending time and effort talking to a seller of a company, you don't want them to, without you knowing, be off talking to other buyers for a period of a number of months. So what you can do with an exclusivity agreement is you can say, okay, we've reached agreement on this heads of terms. For the next 3 months, you, the seller, won't go talking to anybody else. We'll in good faith try to negotiate a deal and we know that you're not going to agree a deal in that time with somebody else. So I think it's an important thing to have as a buyer.
Absolutely, Robert. So key, isn't it? And this particularly with how long, as you said, that you're seeing 18 months to 24 months. If you had spent 18 months, negotiating back and forth to then find that the business was sold out from under you,
Yeah,
you'd be very disappointed and frustrated. So that's very key. Do you see a lot of deals that exclusivity would be included in it?
I would say it's pretty much
Right.
every time unless
Okay.
I mean that there are different types of so then you have kind of auction scenarios. So
Right.
sometimes a business, if it has, if it's able to attract that level of um, interest and competitive
Hmm.
tension, like a lot of deals are bilateral. So a
Hmm.
buyer and a seller get talking and they agree a transaction. So that happens some of the time. There's a strategic fit, or private equity might see different businesses and approach, and over time they agree something and go into a deal process. Other times it's an auction. So you might
Right.
have, for example, a corporate finance house
Hmm.
is kind of agrees with a seller, okay, we're going to try and sell your business for you. And then you have all these different buyers making bids. There you
Okay.
can't have exclusivity because
Of
you
course.
know there's a bunch of others. You might go into exclusivity if you get
Right.
yourself to be the only horse left in the race because you've made the best
Mm.
bid and you're the best buyer. But you know, at that stage, you might, as a buyer, make the point that you don't want to start spending a load of money on due diligence if you don't know that you're exclusive. But it all just
Right.
depends on negotiating position, really, and that sort of thing.
Okay. Okay. That's interesting. Thank you.
Okay, I think we can. So deal structure.
Yes,
So
the deal structure.
again, it's just going into an acquisition. You just probably need to understand some of the different options. These can be tax driven again, without keeping harping back to tax. But if it's an acquisition of the shares in a company, that's one thing. A business transfer is a different thing. So each Irish company has shares, and I suppose typically the transactions we would see is an acquisition of the shares in a company. So you're buying the whole thing, and the business is kind of owned by that company, if you like. A business transfer is different, where you're taking a business out of a company. You're not buying shares. So you're buying a business as a going concern, and then there's different issues come with that, like the employees have to come as well under a thing called Chupi. And there's a lot of different issues if you go to the business transfer route, but sometimes it just makes sense for one reason or another. Um, Often we see pre-completion reorganizations where the group structure has changed around a little bit, and that gives rise to a few legal and tax issues. Then are all of the shares transferring? Sometimes on an M&A deal, it might be only some of the shares and not all of them. And you will need, or you should have, some sort of shareholders agreement if there's going to be more than one shareholder afterwards. And then one thing to bear in mind is there going to be a management incentive or rollover. So sometimes if a buyer is acquiring a whole of a business, you will get that some of the management might stay on, and the buyer might want the management to continue to hold a small stake in the business because that will incentivize them to drive value and to do a good job. So if I own 100% of a company and I'm selling out to someone, and the value of the company is actually quite closely tied to me staying with it, the buyer might say to me, listen, we're going to pay you for the whole company, but we want you to stay on, and to incentivize you, we're going to give you 5% back. So that's what happens exactly in a
Okay.
management incentive, and it's very common, and it makes total sense for buyers, you know.
Hmm. Okay. Great. And then the
Due
famous due
diligence.
diligence.
Yeah, this is a process that could be very demanding for some
Mm.
sellers, depending on whether you're ready for it and what team you have behind you to help, because you know the requests can be quite extensive. So first of all, virtual data room. Nowadays, it's many decades ago, you might have had all documents needed for due diligence physically put into a room somewhere, and it was called a data room. Now it's all electronic, so it's you set up a data room, and there are different types of different sophistications. And there are probably three different thing concepts to be aware of. There's more than three, but what you typically get at the beginning is a standard due diligence questionnaire from the buyer, and that's you might get one on several fronts. You might get a legal one, a tax one, a financial. Just depends on the approach. Now, depending on the size of business, you might be able to persuade the buyer not to go too heavy on all that, and there is tapering and there's tailoring it to the type of business. But the reality is you're probably going to get a lot of questions as a seller, and then it's about being ready or having a front load of the work done and documents that are likely to be requested already in a data room. And then what the buyer will do is usually legal, commercial, tax, due diligence, sometimes other things, depending on the nature of the business. They might want to do environmental due diligence. You know, there's different things that can come up. And then there's a questions and answers kind of ongoing process. So typically the documents will come back from the seller via the data room, and then they'll be reviewed by the buyer's advisors. But the buyer's advisors won't necessarily just read all them saying, "Yay, that's fine. Here you go. Here's our due diligence report." They'll typically say, "Okay, well, you have this contract with a key customer, for example, that key customer, the contract says it's a 2-year fixed term, and that fixed term ended 6 months ago. What's the story? So, this type of thing comes up all the time in due diligence, because the reality of running a business is that not everything is perfect. But then when a buyer comes along and effectively does an audit, if you like, a legal audit on everything, they'll find all these little things typically. And then it's about trying to navigate that path to a point where the buyer is happy to move to closing with maybe one or two protections in the documents, or an undertaking to sort something out afterwards, or possibly something might have had to get sorted before closing, just depending on what it is. So it's all of that, but it's not unusual that things aren't perfect. Just to say that, when you're buying an Irish business, it's just normal. And that Q&A process, questions and answers, goes back and forth. Key legal topics there on due diligence. I've mentioned an example on contracts. You want to see then corporate structure and compliance, that your register. Every company is meant to have a register of members, for example. That's the legal title. It shows who the owners and the shareholders are. Employments. Do we have employment contracts? Do they comply with law? Intellectual property. Is there some horrible big lump of intellectual property that isn't licensed properly, that actually is owned by some contractor, and that you need to sort out? That's a kind of sort out pre-completion type issue. Debt facilities. Does the business have any debt? What do we need to do? Does AIB, for example, actually have the right to kind of call in that facility as a result of this transaction? Do we need to go and speak to them and get sort that out before closing, whether it's going to be paid back at closing or whether it's going to be rolled over? And then real estate can be either largely irrelevant, or it can be a crucial part of the deal, depending on the type of business. You can have family businesses in Ireland that are real estate is crucial to them, and it becomes the big due diligence item in the transaction. Just things that have not over time been correctly documented, rights that are not actually in place that should be in place, and things of that nature that can really. It's a difficult one, actually, because some things, when they're in your own control, can be sorted out, but actually when you need to go to a third party, it's quite, such as a local authority, it can be quite challenging. So that's something that really has to be looked at, depending on the business. Less relevant if it's a tech business, probably.
Okay. Okay, great. I'm sure that's been really helpful for people, because I'm sure due diligence and going into that part of it is quite nerve-wracking. It's what questions am I going to be asked, and what's going to be expected of me to have in advance and have ready, and so many things to consider as well, Robert, isn't there?
Yeah, there is, for sure.
Yeah.
It's just it's a difficult one, and it's probably the most for. You think of different people involved in a transaction. I suppose for the kind of management group, due diligence is the most taxing part of that,
Yeah.
most work intensive part of it. Core M&A deal documents, as I say, just being prepared in terms of understanding what's coming. If it is a share purchase, the key document is a share purchase agreement. If it's a business transfer, so you're taking the business as a going concern out of a company as opposed to buying the whole thing, it's a business transfer agreement. That's the key document to be negotiated. It will take the most time. It will have the most in it. The tax
Right.
deed is there too. The tax deed is, if you have one, it's an indemnity for all past tax of the company, essentially, subject to some limitations, and that. That can sort of, you just have to watch that doesn't get left behind and cause negotiation issues. Disclosure letter, if the share purchase agreement has kind of a suite, if you like, of warranties, which is statements of fact about the company, you then have to disclose against those, it's a slightly legal concept. But if I'm a seller and I give a warranty that I can give a statement of fact in the share purchase agreement that there's no pending claims against the company, I can give that and then disclose against it in the disclosure letter by saying, actually, there is this one claim, and then I can't be sued by the buyer. So that's just the way it's set up by convention. So you have a disclosure letter, and it's another important process. Employment agreements, if anyone's staying on, it may be that they stick with their existing employment agreements, or the buyer wants them to go on to new ones, and that is obviously another point of negotiation.
Mhm.
Transitional services agreement, just to be aware of that, it depends on the type of business. But if you have a kind of a unit, if you like, or a business being extracted from a wider seller group, and that business is reliant on, say, human resources, IT, whatever it might be, the buyer might need those services to continue for a time after closing. So that's where a transitional services agreement is needed. And then escrow agreement, that's only if you have protections in the agreement where part of the purchase price is supposed to go into escrow until certain things happen and it can be released. It might be the completion accounts. It might be that what you're waiting to see, does an indemnity claim crystallize, and then you can take the money. So it's a possible, like, question marks after a couple of those. I could probably have question marks after employment agreements, but they're probably more common than the last
Right.
two, I would say.
Yes. Okay. Okay. Fair enough. Thank you.
Okay, and conscious we're running through our time a little bit here, but
Mhm.
just in terms of the negotiation points that do come up, again, to be aware if you're embarking on an M&A deal, probably indemnities is a big one. If a buyer finds in the due diligence exercise a number of items of risk, they may seek an indemnity from the seller. An indemnity means if a very particular fact happens that the seller has to pay the buyer on a euro for euro basis for that. It might be, to go back to the example I just gave, the buyer knows that there's a horrible claim against the company in the courts, and there's a kind of chance that the claim will be successful. And the buyer says, listen, I'm very happy to go ahead and buy your company for 20 million, but that claim that could be 500,000, or it could be a million, or it could be something like that. If it comes through, you, the seller, need to pay me euro for euro of that amount, just to give a hypothetical example. So that's what an indemnity is. Warranties are kind of more the unknown unknowns. So it's statements of fact about the business, such as there are no pending claims against the company. That's a warranty.
Right.
Then the other things there come up as negotiation points. As a seller, I would want to cap my liability under the warranties. I would want a de minimis in basket, which means that you can't come after me for spurious little claims.
Mhm.
Um, I think then due diligence issues that come up would be negotiation points in the documents. So what are the conditions on completion? I gave an example earlier that we have, if the company has some key customer contract that's actually out of date now, it may be a condition to completion that the seller has to sort that out and get a new one signed up. So, and knowing that we have that runway, that the customer isn't gone at closing, just as an example, that mightn't be
Mhm.
practical. Restrictive covenants means if you're a buyer and you're buying a company, you don't want the seller to go and just compete against you. So if I'm buying a nice tech business from a seller, that the seller sells it to me and I pay a lot of money, and then the seller goes and just sets the same thing up and moves all the customers, you'd feel like a bit of a fool. So what happens is you put restrictive covenants in which stop them from competing with you in that, but it has to be only, they can only, it's in the subject matter of the, or the business that's actually being sold. So it can only be that type of tech, for example. It doesn't stop somebody from making a living, and it can only be for a particular amount of time, such as 3 years. And it can only be for a specific geography. It can't be
Mm.
worldwide, for example, if that's not what the business operates in. Um, we've talked about earnout. I think there might have been a question about the earnout. I saw it
There
pop up.
is actually.
Okay.
I
Yeah.
knew that it was going to come up at this point.
Okay.
So yeah, Richie has said if earnout is part of the deal, should you expect this to be linked to business as usual for the owners, managers involved? If the new owner changes structures or staffing, I could imagine it can make earnout more difficult to achieve.
I think Richie's totally hit the nail on the head there. And when there is an earnout, and I may have explained it earlier, Richie clearly understands what it is, but in case there's anyone on who doesn't, we are talking about, if I come along and I'm saying, right, there's a deal here for 20 million euro is what's
Mm-hmm.
going to be paid for this company. But you know what? We want to pay 15 million of that up front. And if you hit these numbers, if you hit these turnover numbers for the next 3 years, we'll pay you the other 5 million. Um, so that's all very nice. but the devil's completely in the detail there. And you're right, Richie. So as a seller, you need to be really careful because I suppose earnouts would typically only be included if the seller is staying involved in the business because it's obviously outside your control as seller how the buyer does. But if you're staying in the business, the whole point is to then incentivize you to do really well. So I suppose what you would build into the terms is a protection for the seller around that, Richie. So if the buyer totally changes the business and you've no control over that, and then the numbers aren't hit, that wouldn't work. So it's an interesting point. It probably doesn't come up, but like if they're going to, yeah, I mean, I agree I agree it's a point, and basically it's a question of what's agreed in the contract, but effectively the buyer wouldn't typically be able to do that. So if the buyer, for example, buys a company and then says, you know what, actually I'm going to strip it for parts, so sorry about that, you're not getting your earnout. That would be covered in the detail of the earnout, where if the buyer does that, they have to pay you your earnout. You know that was in a well constructed earnout from the seller's point of view and expect to have that protection. But it just depends because a clever buyer might just want to give themselves total flexibility to do what they want. And if you know if their earnout isn't made, then tough. But it's actually a really, if there's an earnout, it's probably going to be one of the, if not the greatest points of negotiation when you get into the detail of it. Okay. Okay, and what else was I? Okay, so a deferred consideration, it's slightly different to an earnout, just to make that point. So an earnout is it might never get paid and it's subject to hitting targets. Whereas deferred consideration, in the example I gave, if it's a 20 million deal, 15 million is being paid up front. Deferred consideration just means I'll pay you another 2 million after 1 year. I will pay you another 2 million after 2 years, and I'll pay you the last 1 million after 3 years. That's deferred consideration because it's guaranteed as such, whereas an earnout is subject to targets. Lockbox completion accounts. So on most deals, the structure of the share purchases deal is that you'll either have a locked box or completion accounts. And this is essentially a price adjustment mechanism. So again, going back to our 20 million deal there, if a buyer is paying 20 million, they're probably, and they're going with the kind of more typical, usually completion account structure. They're paying 20 million on the basis that they expect that X amount of cash is going to be in the company at closing, Y amount of debt, which might be zero, is in the company at closing, and Z amount of working capital, as defined, is going to be in the company. And what then happens is after closing, you have a completion accounts exercise to check whether the cash, debt, and working capital is exactly what everybody expected it to be. If there's an overall better position in the company than was agreed, so there's more cash, less debt, more working capital, or a net of that, then the buyer would have to pay a little bit more to the seller afterwards. If, on the other hand, there's less than you thought is in the company, or a minus in terms of more debt, less cash, less working capital, then the adjustment will go the other way. The other way you can do it, if you don't want all that, is a locked box. So a locked box means you do a set of accounts, a lockbox accounts, maybe a month or two before closing. You say that's the accounts on which the buyer is buying. And the only way there's any adjustment, if you like, is if there's a thing called leakage of value out of the company. So, and leakage is defined, it might be a payment, an unusual bonus to the seller or something like that. And then there's permitted leakage, such as normal salary. So, that's lockbox completion accounts. And we talked about the split signing and closing. I think we're running out of time a bit, Christina, so I better be careful about going on too much.
Well, you're okay. Sorry, I know we've had a lot of chats through it, and there's been questions throughout. So, but yeah, I think we still have a couple of minutes, so you're fine, Robert. Thank you.
Yeah, no, that's fine. And I think I say regulatory pitfalls because it really is a pitfall if you miss any of this or if you don't know about it. Because if you do a deal, if you close a deal that you were supposed to get a regulatory clearance for, the transaction is void and there's all sorts of problems. I won't go too far into it, but
Yeah.
effectively the 20 million that I talked about has to be handed back, etc. So and the deal is kind of just never happened. So the things just at a high level to check out, there's competition. So the competition is quite a high threshold, but you need to check it because there's funny things happen. Essentially, with competition, it's not it's a threat. It's a turnover test. So the combined turnover of the parties in Ireland has to be at least 60 million, and the per party turnover has to be at least 10 million. So for a lot of transactions that won't be relevant. At the same time, you just have to watch it because there can be different ownership structures and funny definitions where two owners of the buyer are above your 10 million, or there could be situations in which kind of a repeat buyer has been told at some stage by the competition, the CCPC, that they need to notify every transaction that they do, even when it's below, even when the target is below the 10 million. So it's just something to be really careful of. And then there can be exceptions to what I've just said, where it's a competition issue, then you have to notify, and then all media mergers, for example, have to be notified. It's just something to be aware of and not have as a total blind spot.
Yeah.
Then, as I mentioned earlier, there's this new foreign direct investment screening regime since January in Ireland. That's a way lower threshold, and it's where competition is kind of any deal that hits those thresholds. Foreign direct investment is where there's a third country undertaking, which can include the UK. So it's a non basically the EU or an Irish buyer is fine, but where it's owned outside the EU or Ireland, that's a problem. Or where it's a direct buyer or investor, that's a problem. And it's any deal that hits certain criteria, like so kind of critical sectors, but it's quite widely defined, so you just need to be careful. And it's any transaction that's at least 2 million ticket size. So
Right.
really a lot
A
is
lot.
caught
Yeah.
there, and where we find a lot of deals that we would see don't hit those competition thresholds, a lot do hit the FDI ones. So
Okay.
it's just really it's new and it's worth being aware of. And then there's sector specific consents. I mentioned, central bank or HICWA. Is there some consent you need to do the deal? You just need to be careful. So that's just it's just something, if you're embarking on M&A where there's a change of control, you need to be aware of it. And then
Yeah.
I've
Sure.
mentioned
Yeah.
signing and completion. I don't want to go on about it, but just
Mm.
there's a bit of a process. You just need to be
Yeah.
clear on who needs to sign what. Are the signatories lined up? Are you doing it back in the day, whenever you had a closing of a deal, everyone got in a room together? Now that's increasingly rare. It's kind of electronic signatures and all the rest of it. So you just need to watch that. Then there's Irish law rules about electronic signatures. You just need to be a little bit aware too, in terms of deeds and things. So just to be prepared on that. It's really up to your lawyers to know about that and talk to you, but
Mm.
just so that you're not caught short and suddenly signatories aren't available when it comes to the time. And again, things surprise me sometimes. You've got a lifestyle event, a huge lifestyle moment for a seller, and suddenly they're on holidays in Portugal for 2 weeks and they're not available. So just be really aware of those things, and it's all about planning and being aware of what's required of you, I suppose.
Okay. Okay. Great. Yes. And I know your next slide is
Yeah,
just covering
it
the
just
key takeaways. So good to have a couple of minutes to summarize because you've
yeah,
gone
no,
through a lot there, a lot of information.
yeah, and I'm conscious of that, but there's a lot in it, and there's probably different folks on the
Mm.
that have attended who are very close to a process such as this, or may have a lot of experience
Right.
in doing these processes,
Mm.
and then others who it's much more new to.
Mm.
Um, the key takeaways, taking all that into account, I think understand the stages of the deal well in advance so that it's not a surprise. You know what's coming. I think momentum is crucial. Be proactive. Don't just be reactive. Keep pushing that momentum forward. Have somebody, whether it's yourself or not, that's going to actually be in charge of pushing, 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 because you need somebody like that. People have, unfortunately, I mentioned the 20 to 25 people involved in a deal. They will have a million other things to do as well as that deal, usually unless it's a really intense, short process. So they will get distracted and they will miss an email or they'll delay with an email. There has to be somebody pushing them and being on top of everyone. It's not binding until it's binding. So what I mean by that is just be really aware and careful. A day before the thing is meant to be closed, it can still fall over and the buyer is not obliged to go ahead. And you, whether it's buyer or seller, are not obliged to go ahead. You're not caught, you're not bound. So just be aware of that in terms of running the ongoing business, not telling people you don't need to tell about it. There's confidentiality, but there's just, you know, the communications with your own customers say, and just always be mindful what happens if this doesn't go ahead. So it's just being aware a deal is not binding until it's binding. I've said there patience, resilience, perspective. Be patient. It takes time. Yes, be proactive. Yes, push it forward, but you have to be patient too because stuff happens.
Yeah.
Be resilient. There's always bumps on the road in a transaction. There's always things come up that drive you up the wall, but you just have to ride with it, and have perspective on that. Don't be getting annoyed when that point keeps coming back, or the seller or the buyer on the other side won't drop the point. Just try and have perspective around it. Have perspective. If a load of questions are coming in, it's not personal. It's not your company. It's just the way it works.
Mm-hmm.
So there's all of that. If you're on the sell side again, people are coming at this from different angles. I know that. Be prepared for the due diligence as best you can. Don't be naive in terms of thinking that they're not going to ask the questions and you're not going to have to do this work. You are going to have to do it. It's almost inevitable unless you've got an incredible negotiating position where you can persuade a buyer to just forego a lot of it. But it isn't the way the world works at the moment. A lot of buyers, if it's a corporation, they're the person they have to answer to someone and they can't take on risks, in terms of a certain type of thing that they just didn't look into. So you just have to be prepared for what's coming. And so those are probably the main takeaways, I think, Christina.
Yeah, and Robert, you touched on something exactly there. So if you're on the sell side, you can be sort of, ready and wanting to sell, but if you're not ready with, the likes of your due diligence, and you touched on it earlier with like the term sheets, knowing what terms you want, for example, going into that negotiation stage, so you're not holding things up. And you mentioned earlier data rooms, and I know that when yourself and Nell Marie discussed in advance of this, we
Yeah.
talked about data rooms, and that there's loads of different options, but there's nothing to stop a business that wants to sell in getting ready with that data room, having their due diligence, and having all of theirs almost like a Q&A about their business pre-populated, so that they're sharing more information maybe that's necessary, but that at least that there's something there always that they're populating in advance, so that when someone comes to the table as a buyer, they're ready for it. And that, I'm sure, would speed things up significantly.
I think that's exactly right, Christina. I think, and there's a lot of different types of data room out there. There's
Mm,
ones that are very, sophisticated organizations will charge you that do this, or
mhm.
have units that do this for a living. Then there's actually ones out there that are free. I just be careful what you use. And there are
Yeah,
certain ones, I don't know if I want to name and shame any, that
yeah,
are very difficult to use. But if you can't get a clear index and it's not clear that the document folder structure,
yeah,
that's just a nightmare for everybody. It can really cause problems on a deal. So some of the free ones are good
yeah,
now. I think some of the ones that were used a bit maybe 5 years ago, or that were free, did not work. They were not fit for purpose. So I totally
right.
agree, Christina. And there's no
Yeah.
having that depository in an organized
Mm,
way is a very, very good discipline if you're thinking about raising funding, in fact,
yeah.
or
Okay.
selling.
Yeah, yeah, great. Okay, so we haven't had any other questions in just now, and you've finished just bang on time, Robert. So thank you so much for that. I'm sorry if you felt rushed in the last couple of moments, but it was a really great discussion today. I'm sure that everyone has left with a lot of key takeaways there. So thank you so much as always for your time. Oh, sorry, I've just realized that I've forgotten to put up your contact details. Forgive me.
No,
So
that's yeah,
yeah,
and happy, if people are on, if they want to reach out with any questions, please do drop me a line, or get in touch.
Perfect. Yes. And I'm just sharing your email address in the chat there for anyone that wants to directly click it as well. Yeah, thank you so much, Robert. As always, really enjoyable discussion with you. And I've no doubt that we'll catch up in the next couple of months and have another webinar. But yeah, today's been great. Thank you.
Thank you very much, Christina, and to Kenora for hosting.
Yeah, thank you. Have a good day now.
Appreciate it. Thank you very
Thanks.
much.
Bye
Cheers.
bye.